Okay, and we appear to be live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon, gentlemen. This is first case this afternoon is 21J88, 21st Mortgage Corporation versus Bruce Clark. And counsel, I'm going to ask you to help me with your client's last name so I pronounce it correctly.
Yep.
Demusgene?
Demusgene, yep. That's
Demusgene?
Yep.
Okay. And I'm going to ask you each to say your names for the records, if you would, please.
Attorney Lucas McCardle for Bruce Demusgene.
Good afternoon, Your Honor. Michael Hagopian for the plaintiff.
Good afternoon, gentlemen. So I'm going to, we begin, I believe, with you, Mr. McCardle?
Correct. Yes. Yes. My
Correct.
my client is the appellant in this matter, just appealing from an order from the housing court regarding a use and occupancy. The bond was properly waived pursuant to an affidavit of indigency. I apologize for the voluminous submission that I provided, but pursuant to the new ruling in King, I think the underlying merits seem to be a factor that's played into the assessment. So I wanted to try to provide some of the record, and I know it's a bit cumbersome to maybe sort your way through, but I wanted to provide a little bit of background because this is a overly convoluted matter that goes all the way back to 2010. Regarding a federal court order that was in favor of my client and actually prevented the foreclosing entity from enforcing this mortgage obligation whatsoever, collecting mortgage payments at all. There was a permanent restraining order on this.
I'm gonna interrupt you because I think it's agreed, right, that there's, and I'll hear what you want to say, but let me just tell you where my head is and what my questions are.
Sure.
For right now. One, as I understand it, the housing court judge said it was a non-frivolous motion. I'll have to look deeper into I think they told me 500-page appendix that was filed today for me to have an informed opinion on that. But still, given that, as I read it, it was agreed that a fair use and occupancy was $3,500 a month. The judge set it at $3,000, right? How do you distinguish? I'm looking at Judge Kafker's opinion in Bank of New York Mellon, right? And when the court talks about, while we seek to avoid creating a monetary barrier, a defendant who remains in possession after a foreclosure is not entitled to remain on the property for nothing, even if he or she is indigent and even if he or she has a non-frivolous defense. My understanding is your client isn't willing at this and hasn't paid even like taxes and insurance kind of expenses, never mind the $3,000.
That's correct. And it wasn't, I just want to clarify, it wasn't agreed upon as far as a use and occupancy or fair market rental. That was from an affidavit provided by the plaintiff regarding the alleged fair market rental, just from a drive-by exterior look at the property. That's all that was based off of. And then a prior submission that the plaintiff made for $2,800. So the judge kind of took the middle number of those two and suggested that was fair market. But in any case, I think
that's right. And I did see that. You're right. I'm sorry.
So the analysis in King, it starts off with the fair market rental value, which I think is a fair starting point, even though the plaintiff doesn't really provide any, landlord services that would result in actual fair market value, plowing the driveway, quiet enjoyment. So the fair market value thing is kind of odd in my eyes to start with, unless they're actually providing the services of a landlord, which they're not.
Well, no, but I mean, there's an apartment, right? There's heat, there's running water, right?
Right, and my client is paying for all those things. I agree with the taxes and insurance, but pursuant to the prior order, the judge from the federal court said you can't enforce any payments against this client. So the fact that he hasn't paid in a long time is, it's kind of part of the dispute, is that the judge made an order that says you do not have to pay this mortgage. This mortgage holder cannot enforce it.
To a prior owner, right?
Right.
And the question, the live issue is whether that judgment is enforceable against this owner, right?
Right. I mean, there's several issues, to say the least, in this case. But I would also suggest that something it's hard to ignore is the fact that his longtime girlfriend, who has been in possession of the property for all times with him, is not part of this judgment. So the plaintiff does not have a legal right to possession, and all of the bonds, section 2, chapter 239, section 5 and 6, are all specifically related to damages for withholding possession. That's the exact terminology. So if they're not how is my client withholding possession when he still has a clear right to have possession under someone in legal possession? It's an odd scenario. But the judge at the lower court level made it an issue and said, you should have properly found out who was living at the property. This is a mistake of your own making. You don't have rights to possession right now because someone's living there legally still. So that's the problem.
But possession's a different issue, right? Right? I mean, at least does either party paid anything since 2007?
To the mortgage company? No, I mean, they were acting pursuant to the 2010 judgment. And then this didn't come, it wasn't assigned until there was a bankruptcy in 2016 when there was first some type of demand from 21st Mortgage, the alleged new holder. But that's why it's to just say, hey, he hasn't paid any money on this since XYZ. It's hard to, I don't think that's really a legal argument in this case, because that's part of the dispute, was that it's not an enforceable mortgage. It was determined to be predatory. It was determined to not be enforceable and void back with that 2010 judgment. So to hold it against him that he hasn't been paying pursuant to a judgment is kind of hard to utilize in the analysis, in my opinion, to some degree, or at least like there needs to be a little bit of a balance there. And I understand anyone appealing should probably have some skin in the game to show that it's not just some frivolous appeal. And I would suggest that my client would be willing to do that because he's very confident in his appeal. But it makes it an impossibility, obviously, with someone who's indigent to pay $3,000 a month. And I think where the strongest footing is the fact that they do not have a legal right to possession right now, and reason they just initiated another summary process action against the other occupant who's in legal possession. And summary process is for possession. You have to show that you have legal possession of a property. If someone appeals and there's still someone who has legal possession of their property, even if my client didn't appeal right now, they couldn't go in and move him out. They don't have a legal right to levy on the execution, even if he didn't appeal. So how can they force him to pay use and occupancy when he has a legal right to possession of that property underneath someone else's legal right of possession? So I think it's kind of I couldn't find any case law on the exact scenario here. I think it might be an issue of that hasn't really been decided at the highest levels. But I would suggest that the reading of the statutory language together with obtaining possession, the most important aspect of a summary process claim, they don't have a right to possession. That was clear in the judgment. They have a superior right over Bruce Demachine, but they don't have a right to possession of the property itself, which is more important. And until they obtain that right to possession of the entirety of the property, they can't force someone to pay a use and occupancy or anything.
Back in 2007, when sometime after that there was a foreclosure, did your client, and I'm sorry, the woman is referred to as Valerie, and I know there's a last name somewhere, I don't mean to be disrespectful, but did they own it together as tenants in common or joint tenants?
Nope. He's owned it individually. He had a divorce. The only reason he took out this mortgage in the first place actually was
to pay the divorce settlement.
And then his now Valerie, him and Valerie have been together, I think.
What is this person's last name?
I'm sorry, Divine, Valerie Divine.
All right, and it's
Divine.
And why does she have a right to possession?
because she entered it under a legal right. It's just, I mean, by law, she entered under a legal right. She entered, it's not like she didn't come in while someone else owned the property. She came in while Bruce owned the property. She has a legal right to possession. She has her own rights in summary process as a non-owner, as a tenant. So her rights are different than my client's rights. But in either case, she still has possessory rights of the property. I know we could talk about no one paying rent or whatnot, but I think that misses that major point is how do you get over the practical part of it, which is she has legal possession of the property by law. She has legal right to possession of the property by law right now, as we speak. And I think, if we want to get into some of the merits of the case, this case went through 3 judges at the lower court, and the way it was decided in an expedited fashion was beyond reason to me, with how anybody could get through all those submissions and make a decision in less than 30 days. It was seemingly like a spiteful action. Like I don't like to say that about, judges making decisions, but once I moved to stay the matter so that I could get a determination from the federal court regarding its own order, I was asking them to provide a clarification on what their order meant on the successor and interest, because contract privity law, you take it subject to your predecessor and interest. You don't all of a sudden become a new owner without taking subject to that same claim. That's not how property law and or contract law works.
Is there litigation pending in federal court now?
Not pending right now. No, we're just began settlement discussions trying to get this resolved. It's been pending it's been, in courts for so long. If we're not able to reach some settlement, then yes, I'm going to file an independent action to try to get everything unwound, which I'd love to avoid doing.
And the settlement is with a potential federal court case or with this case?
No, it would be all disputes, everything. We would tie everything up into it. Nothing would be left in dispute whatsoever between the 2 parties. But yeah, this case would be taken care of if we were able to. And I can't assume one way or the other because I haven't heard anything back yet. And I can leave that to Attorney Hagopian. But we've had just brief discussions prior to today's hearing, and he seems like there's some reasonable discussions going on. So I'm optimistic, but we still obviously have to go through these processes anyway to protect.
I still have one case before me, which is the
motion, right?
Which is the use and occupancy order.
That's all. Yep, that's everything that's in front of you. Correct.
Is there anything you want to say about that you didn't get a chance to say?
The case in chief, there's some huge holes in the case in chief regarding showing a prima facie showing of possessory rights, including the chapter 244, section 14, intent to foreclose notice, which is part of the statutory power of sale and part of the statutory power within the mortgage, strict compliance with PINTI. That wasn't even provided as an exhibit in the summary judgment submission. So you can't obtain an order for demonstrating strict compliance when we're trying to establish that it's not without submitting those documents. There's a dispute about the note pursuant to Eaton. There's the other dispute was regarding the admissions and interrogatories and summary process are supposed to be made part of filing. You're supposed to file it with the court pursuant to summary process rules. And we mistakenly thought that they were properly filed with the court. So when we made references to the admissions and the interrogatories, which were, some of them were, in my opinion, were fatal to the case when they admitted they didn't hold the note at the time of the foreclosure and weren't the actual entity that foreclosed. When I referred to those admissions and the interrogatories, the judge said they're not part of your summary judgment submission and didn't consider them or make some temporary ruling that said, can you please put these on record correctly as they're supposed to be, so that the references are clear and I can make a better determination on the full record. So I think there's some errors of law that I think are clear, and I think there's an abuse of discretion with how this was handled. I'm relatively confident on in at the appellate level. And I can rest on that and let my brother speak. But I believe that my client should maintain the opportunity to appeal this case just because of the amount of litigation that's gone on. This case alone, if you look at the outline of what the submission I put to the court, just a statement of facts, you'll see that it's convoluted and a lot going on, and it bounced from one judge to a second judge to a third judge, and there wasn't the diligence that is required for a fair determination. In my opinion, just wasn't present in this matter. And I get it. It's a lot to digest, but it needs to be digested, and a fair determination, I think was not made, and was not. I don't think everything was taken into was reviewed with the thoroughness that is required. And that's it. I'll rest on that. And I thank you very much for your time, Justice Hammond.
Okay. Mr. Hagopian, what would you like to tell me, sir?
Thank you, Your Honor. Your Honor, counsel seems to be focusing on perhaps one aspect of the King case, which is controlling. Actually, the SJC laid out quite a few factors for determination, use, and occupancy. And although in this particular case, we're talking about use and occupancy, it's still in the nature of a requirement as a condition to file an appeal. Counsel's talking about use and occupancy in the more traditional sense of landlord-tenant. The purpose of the statute, as the Supreme Judicial Court said, is to level the playing field. His client appealed from an adverse judgment in the housing court, and to level the playing field, he has to post, and the bond was waived, but the second aspect, the use and occupancy, is to be paid as a condition of the appeal. To take that away and not level the playing field while the plaintiff continues to pay taxes, insurance, and the carrying cost of the asset is unjust, unfair, and contrary to the SJC's decision in King. I have some difficulty.
Well, one of the things, the other things they said, though, and I hear you, what was also to weigh the relative positions of the parties. Your brother argues that in fact that the judge considered his client's indigency, but didn't talk about how much damage it was doing to your client, as opposed to, the classic little old lady, right, who lives in the house and needs it to keep, the house, needs the payments to keep the house.
Actually, I don't necessarily agree with that, Your Honor, because in the judge's decision, he said, and I was looking because I thought he had wrote down the quote, that he said he was not unmindful of the plaintiff's, of the defendant's position, with respect to his ability to pay. However, as the SJC stated in King, that's only one factor. And the fact that he can't, or it may be difficult for him to pay that, should not be determinative of whether there is a use and occupancy order. And right, the hearing justice did take that into consideration.
Certainly, yes. The hearing justice took into account the ability of the plaintiff the appellant to pay, but didn't seem to look at the fact that arguably your client is able to bear the burden of sustaining this, where, without looking at that your client's ability to sustain this time period.
Well, that's contrary to what the SJC held in King. Your Honor, what I had started to say earlier was I'm somewhat troubled by the lengthy filing that was made on late Friday. I received it, well, actually I received it this morning. I was out of the office on Friday, but the voluminous appendix, as well as the brief that was filed, wasn't provided to me until that time, and actually goes above and beyond what was actually argued before the housing court. So I'm somewhat troubled by being blindsided by that filed at the 11th hour. But to address a few of the issues in there, it appears as though from the date on the front, this was drafted in January. This court should be aware that the defendant has had a number of opportunities to raise its issues in the federal court. There was the 2010 case, which was opened and then closed. There was a subsequent 2016 case, which was directly addressed to 21st Mortgage. That case, which included many of the claims that were raised as defenses, was dismissed with prejudice. Now, that was addressed before the housing court. Subsequent to that, my brother filed a motion to vacate that dismissal. Judge Young, I believe it was in November, denied the motion, and the appeal period for that time, for that motion, has lapsed. After that, I believe it was last month, we appeared in front of Judge Woodlock in the federal court. And my brother tried to, well, he had filed the motion to reopen the case, name 21st Mortgage, and adjudge everyone in contempt. That was also denied. And I believe the appeal period, well, yeah, the appeal period may have run on that as well. But in any event, he's had two federal court cases, tried to reopen both of them, was denied in both, is still raising those same issues here, and I suspect he'll raise them on the merits, when they've been decided now by three different judges, Judge Woodlock, Judge Young, and in the housing court. In addition, if that 2010 order was as valid as my brother says it is, which I disagree because the dismissal of the 2016 case took care of it. But if it was still valid, where was the preliminary injunction in the state court prior to the foreclosure? Where was the preliminary injunction prior to the summary process? No action was filed until this case was on the verge of being decided by the housing court. So I'm not, some weight, may be given to that, but looking at the totality of the cases that are out there and when these motions to reopen were filed, they were filed after the fact. If there was truly a reason to stop the foreclosure, one would think that it should have been filed prior to the foreclosure. I also take issue with what my brother said about the discovery. He had defenses to raise based on discovery. It was his obligation to put them in. To say that the court rules require the discovery to be filed, my brother should go back and, I reread the rules in the standing order. I believe it's housing court standing order. I wrote it down, so I would. Housing court standing order, I believe it's 2-19. Specifically states that demands for discovery are filed with the court because obviously the automatic continuance of the initial hearing is conditioned on the a filing of discovery by a defendant. But it's housing court standing order 1-96. Basically states that although the demand has to be filed with the court, the responses do not. And that dovetails with, in that standing order, it refers to Rule of Civil Procedure 5D2, which again, the responses to discovery are not filed with the court. To raise these now when they weren't raised at the time of the hearing, it just appears that we're throwing everything that we can at the court without looking at the actual elements of use and occupancy, the fair market rental value of the property, the amount owed per month on the mortgage, the number of mortgages, months that no mortgage have been paid, the payment of real estate taxes on the property, which my brother concedes my client's been making, payment of the insurance, which my brother concedes that my client's been making, the expected duration of the litigation. Now he's talking about filing another federal court action. Whether that survives or not is a question to be seen. But given the appeal on the merits, I know things are moving a little faster now, but generally I don't see this case being resolved before the end of the year, by the time it's docketed and set for hearing. So he's asking my client to carry all the carry costs while he has no skin in the game, and takes his appeal. And I understand that there are some equities that weigh in his favor, but again, it should be a balancing. It shouldn't be 0 or nothing. And he should be required to pay fair use and occupancy. The SJC said that the landlords are not to be charged with providing a public service for public housing. It's just not the dictate of the statute to do that. And
can I just say, were you
absolutely
surprised by the argument that Ms. Devine is rightly in possession and that you can't bring the action, or were you surprised by that argument?
Absolutely. What happened was, as our course, this isn't a standard, again, it's not a standard landlord-tenant case. So there is no privity of a lease between the plaintiff and the defendant. We knew that Mr. DeMachine was the prior owner. We knew he was residing there. We don't have any access. Our client would have no access to the interior of the property. So he was served with the notice to quit. As a matter of course, in a lot of these landlord-tenant actions, we also send one to all their occupants. And if we receive a response that someone else is living there, then we know. But short of that, if someone wants to be deceptive, they can and say nothing, and we wouldn't know. It's not like the plaintiff can go into the house, and they don't have the rights that a normal landlord does. And at no time during the litigation, I went back and tried to comb through all of the documents. Nowhere does Mr. DeMachine ever say, hey, I have a defense based on the fact that I'm living with someone. And I question whether she's a tenant because he was the former owner. Was she living there as his guest? I suspect she was. But since that time, and given the information that was filed, a summary process action was filed, and it is pending before the court. So I'm sure we'll find out more about it. But yes, this information was a big surprise because it wasn't raised until after the fact. And in fact, it wasn't even raised until the use and occupancy motion. So, whether Mr. DeMachine was trying to hide it or whether, he felt that silence was the best, but Ms. Devine never filed an answer. She never responded to the notice of quit, which was served on all our occupants. And there was no way for our client to know.
Is there anything you want to say that you haven't had a chance to say?
No, Your Honor. I think the only other thing I can add is with respect to the fair market rental value, we did provide an affidavit and it was uncontradicted. There was no contrary affidavit or testimony to dispute any of the information that was put before the judge. And although my brother, tries to say that the housing court justice issued a very quick decision, a decision within a month is not a quick decision. I still remember the days we used to get it right from the bench. You'd argue your motion and you would receive a decision right there and then. I might be showing my age, but that was more of the norm than waiting a month for a decision now.
Especially in the housing court.
Yeah, in this particular decision, though, the housing court judge spent quite a bit of time deciding this motion. If you look at the date it was argued and the date the decision was ultimately rendered, put a lot of thought into this. There was quite a bit of time that went by. And he gave a written decision. And so based on that, I do believe that the hearing justice did take all of the factors in King into account, and his decision should be affirmed. So
Well,
unless, Your Honor.
It for me is right. It's just a question of use and occupancy and whether.
Correct.
Right, that,
And we'll have our day to argue the merits when it's docketed with the appeals court.
all right. All right, gentlemen, I'm going to take it under advisement, and I thank you both for your cooperation here today. And
Right.
take care.
Thank you, Your Honor.
Thank you, Your Honor.
All right, we are live and on the record.
Well, good afternoon. This is for the record. This is case 21J84, appeals court in the appeals court. Barajas versus Ruiz. If I name the names, I'm hopeful. Please feel free to correct me. Ms. Ruiz is here pro se, and Mr. I'm going to try to do as well as Secareccio. I got that close.
Yes, Your Honor, very well.
All right, thank you. And so, Ms. Ruiz, I believe we hear from you first. Is that
Hi,
right? Hi.
I guess, yes. The reason why I'm here or requesting this is because they had put a 48-hour notice on I received it on February 26th here, I believe it was. And it was for us to be out for March 2nd. When I got the 48-hour notice, it stated that we had missed court on February 22nd, which I had actually never received a notice for. I went to housing court in Lawrence. I live in Lowell, Mass. I've been here. Me and my husband, and I apologize. First of all, my husband could not be here right now. He is at work. He did try very hard to try to leave as early as possible, but work is not he's an essential worker for Market Basket Warehouse. He's been there 17 years. So I'm here for both of us now. We lived here.
Let me ask you a couple questions, okay? And then I'm going to give you time. We've got the time on the screen, but I'm not necessarily going to hold either of you to that. I want to give you each to feel like you've had a chance to be heard, okay?
Okay.
You say that you made some payments, and I'm having trouble looking at the receipts.
Right.
And so when did you pay, especially we're talking January and February, right? Beginning of January, beginning of February. When did you pay and how did you pay it?
Okay, so first of all, well, I did confirm now with the lawyer. He did state to me that he never actually sent an email to me with the account number, and I did receive an email on his behalf. But apparently, the guy from Western Union did state that there was scams going on, but I don't see how someone could actually get a hold of the attorney's email and actually email me on the date where I told them that I was going to pay the rent.
Let me just say, do you have an email that you say came from Mr. Secareccio that gives you an account number?
Yep. I forwarded it to him today earlier. I spoke to him a few minutes before we hopped on, and he sent it. He did state to me that he did not send that email. And he said that he had never given me an account number. So this is the first time that him and I had contact, about it.
So this email is not in the papers that I have, right? That we have already here at the court, right?
Yeah, Lawrence said that they wouldn't take it. And when I was at the district court making the appeals there, he couldn't take it off the screenshot from that I had on my phone with the pictures, because I tried to forward as much information as I could, but I did forward it to the lawyer today. So it only states pretty much that it would be the only receipt that we had to save the receipts, that it would be the only copies that we got after the payments with the tracking number and the account number. And then it stated so I wrote to him first. I wrote to him, the lawyer, stating that we were going to be late on our first payment, The first payment was supposed to be on
Well,
January
you
5th.
said that, in fairness, you said that, as I saw that email, that was on January 11th, right? So it was already late.
No, on the 5th. On the 5th, I wrote to
It
him
was
that we were
due
going
on
to
the
be late.
5th.
Yep.
It was due on the 5th. The email I saw was dated the 11th that said, looks like we're late, right?
No, I wrote to him before that, and we made our first payment on the 8th. That's when I got the email from him that he stated he never sent with the information. So I'm having a hard time figuring out how I got an email stating on the same date that we promised to pay the rent, that how is it that I got an email from his computer or his email stating that it would be with an account number and how to make the actual payment to the escrow account. Now I
All
went
right,
down
I'm
to
gonna,
the
hold
actual
on,
place.
I'm just gonna stop you just for a second. Mr. Secretary, did you see that email today? Like an email that seemed to be from your account? I know this isn't the way we usually do things in the appeals court, but this is really a factual issue, and I gotta kind of do it this way.
Okay, so Ms. Ruiz called my office earlier today. We had a conversation. And that email, the alleged email, the topic of that came up. I asked her to forward me that email, okay, which would require her to go into her email account, get the email, click forward, and have that sent to me. That way I would be able to see the email account from which it was sent, the email account address from which it was sent.
Oh, no. Okay. So let me do that now because I actually screenshotted it. So I'm going to forward it completely. Sorry. I
No, can I-
screenshotted it.
That did not happen, Your Honor. So all it says
Go
is
ahead.
my name without a middle initial, and it's a screen capture. It's a JPEG image.
Yep.
So she didn't send me an email, Your Honor. She sent me an image.
Yep.
Got it.
I'm sorry.
And
I'm gonna forward it now just so that he could have it forwarded. I'm sorry. He's right. I actually did screenshot it.
Right.
So I'm gonna forward this copy
You
now.
understand that why he wants to see the email.
Of course.
right?
Yes, of course. I already saw that this was, yes, of course. And he's correct. And he is correct. And after we made the actual, the initial, now that we actually found out that it was fraudulent, my husband and I have to go report this because this money went into an account that we have no clue whose it is. And now that we actually went back, they state that the account was actually closed. So our money went somewhere. We have no idea to who. And I mean, he did say, oh, maybe it was a prior landlord. I've been here 7 years. This is not to a prior landlord. This is not normally how I pay my rent. So obviously at this point, these payments that we made were not made to him. And this was our Western Union scam. But these payments were made on the dates of my rent. And starting on the 8th, I made my first payment of $900, which is exactly my rent due. And then starting on my the 8th, and then after the month after following, which would have been February, we made the payment on the 4th. We were a little bit short. I made it for $810, and our rent is $900, so I was $90 short. But again, now that we actually know that this account was a fraudulent, when I went back to the Western Union, they stated that they couldn't give me any information, not even on the account holder, because it was already closed. And I stated to them that I made all of these payments, and they told me that now I have to go with these MTCM numbers with the tracking amount and the amount that I actually paid to the police and report this. Because these were all made on the dates of my rent due.
did you see, Your Honor, there was a, I don't know if the court can see that, but I can't make that out. But as you
Yep.
see, there was an email to me.
We can't see that, Ms. Ruiz. We're gonna have to.
Right.
Let me hear from it. I'm gonna give you, I promise you.
Yeah,
I'm gonna
no,
hear
go ahead,
what
go
you
ahead.
have to say. Let's let Mr. Secretary speak for a moment, please.
Well, Ms. Ruiz maintains that she made a payment on the 8th, but then why did she send me an email on the 11th saying she hasn't made the payment? All right. Also, that that account number is not even close to my account number.
Yeah. So on the, as you can read, it did state that they wanted arrears paid, and we had a contract stating that we wouldn't pay anything on the arrears. I replied to that email stating that if we went back to the contract, that it would state that we didn't. But then I got another email from this account that is obviously not his, stating that we did have to make payments on the arrears or we would be violated. So now I started making payments toward the arrears, and I did write an email to him stating on the 11th that we hadn't made the payment because I couldn't afford to make a payment on the 4th or the 5th, and then again another one on the 11th.
Right. As I understand the agreement, you correct me if I'm wrong.
The original agreement.
Right. Well, the agreement as of about December, right? That you could stay till May 31st. But you had to pay $900 on the, as I recall, the 5th of January, the 5th of February, the 5th of March.
Correct.
And that the first January and February would be paid, at least the last couple payments would be paid to the lawyer, and he would put them in an escrow account and you'd get them back. That's what the agreement says. And you would get them back. Maybe you didn't understand it.
All of the payments were made to him. They were all going to be to him.
Okay, but at least the last couple were going to go into an escrow account. That means that he was going to hold them and you were going to get them back if everything, you got out and everything was okay, right? Counsel, right? The last 2 months were going to be held in escrow, and if they left without.
They were all going to be held in escrow.
Just to modify
Clarify.
a little bit, Judge, to clarify that. You're right. The agreement says that I will hold the last 2 months, April and May, in escrow. It doesn't say that the payments will be made directly to my escrow account. It doesn't say that. It says I will hold the payments. And I
They
sent.
should hold it. Okay, fair enough. All right, thank you. And that's a fair distinction that I missed. So did you, what do you say that you did about March, Ms. Ruiz?
So we also made a payment in the amount of $810.
And you made it to this same
I'm
fake
sorry.
account?
I'm sorry. No, that 810 we have here in cash. We have it right here. We have the 900 right here. We held it because the 26th we received the 48-hour notice.
Okay, but I thought because you got on the 26th. So
yes, on the 26th of February, we got a 48-hour notice, so we withheld. But I did go back to make the payment actually initially so that I could have the receipt. That's when they stated that we couldn't make the payment. I thought there was a glitch in the system that day. We ended up leaving. I ended up having a couple of days in hospitalized. I had a kidney failure, and coming in between not receiving the packet from the lawyer sent me a big packet with stating that it wasn't true that these payments weren't made to him. So I wasn't able to actually go through that information until today, which was just cutting it really close. Because if I was able to look at this before, then we would have kind of put 2 and 2 together and say, okay, well, you're making payments somewhere where we're not getting them. And we would have obviously never made 3 extra payments to somewhere where it wouldn't have gone to. I would have never made 3 payments to somewhere where it's not going to. So I do have $900 here cash for March that we did not make. And then initially when we went back to go find out more about this account, they did state that it was closed now. Now that it's closed, there's nothing that they can give me, but I need to go to the police and report that 3 other payments that I made prior to, they stole, because this money, they can't even give it back to us.
Is it 3 other payments or 2? January and February?
Yes, I say 3 because we ended up making 1 payment towards arrears that they were requesting, but it was not him. It was not him making the request. Obviously, he was following through the actual contract. He never broke that. So whoever wrote the email requested from the arrears. And I said, well, on the contract, it says that we didn't have to make the payment. But then the email person wrote that if we didn't make a payment to the arrears, that we would go into violation. So obviously we didn't want any problems. So we made a payment to the arrears. So that was initially the 3rd payment.
Could you pay him if you had to right now, or, pretty quickly, could you pay the $1,800 and plus the $900 you've got?
So I only have 900 in cash right here until I go fight this now, because obviously I don't know how quickly they're going to be able to reimburse me.
So there's no other way that you can come up with the payment to make the landlord whole, so to get us.
I could make her, I mean, I
31st.
could give her 900 today and then next week give her maybe another 9, but I don't think I'll have the whole 18 unless they make me whole at the Western Union. I just don't think it's going to be that fast. I tried to call them today, but the call was taking so long that I had to get off to be able to get on here on time.
Okay.
But I would definitely, I really want my money back. This is not something this is not free. I made $900 and then 2 8-10 payments on the same dates that this was due. So this is a lot of money. This is not free.
Okay. So is there anything you want to say that you haven't gotten a chance to say?
I mean, I just want to make it clear that we've still been looking for an apartment. I actually have a meeting tonight to look for another apartment. We have been doing our best as much as we could. Considering that I just came home with kidney failure and having 4 kids, it's just gotten hard, a little bit harder. So I don't want to make this emotional. I just want to get by. And I understand that she needs her payments as well, but these payments were made to somewhere obviously that he did not have a control of, and neither did I, because I would have never made payments to somebody that we don't know.
And you understand I can't, at least in the copies we have in the court, can't read the receipts that you have from the Western Union. I see a couple of undated notices that say Western Union, that say transfer this money to an account number.
Yeah, they were all ending. It was all the same account number. They were all ending in 7248. One of them for 900, 2 of them for 810. One of them
Right,
January 8th.
But they don't, on the slips we have, they don't have dates, and they do.
So they do have dates. They are a little faded. You are correct. They are a little faded, but they do have dates. But the thing is that I need to get all this. Luckily, I can see the control number on them where I can actually give this to Western Union, because the control number will tell them exactly how much I transferred and when I transferred it.
The slip I have doesn't have a date, just so you know.
Yeah, they're really hard to see on the bottom because they are faded out.
The slip I have, and at least this thing that says Western Union send money.
Right.
Oh no, yeah, these payments, but these are not receipts. These are the ones that I actually physically wrote out over there, because these are the ones that you would write out stating
right
where you would send it to. These are the actual receipts that you get when you actually make the money transfer. Now on the top here, they have an MTCM number, and they can trace this to where it went to, what date and how much. And I need to give this now to them and to the police to make sure that they can actually look up. Now these numbers here are pretty clear. I have all 3 of them. So I can definitely make out these to them. But regardless of this taking place, this is going to take a while before it gets back to us, before they get back to me. So I'm not sure. This is not going to take a day where they're just going to fix it all in one day, because obviously now whoever owns this actual account ending in 7248 closed the account. They knew what they were doing.
Did you get to say everything you want to say?
Yep. I mean, I just want them to understand that we are still at peace. We're not trying to start any problems. We are obviously, willing to budge with trying to keep the peace here. Trying to keep it as quiet as possible with 4 kids, 1 with autism. I'm expecting, so it's just hard, and being with kidney failure and a baby and 4 kids, we are still looking for apartments. I don't want her to think that we are making it impossible. We are still trying to be here before May, which is a short time considering that we are already in March. So we are trying our very best just to make it as peaceful as possible. And of course, if she would just agree to with the lawyer, we could just make the payments how we were making them directly to her downstairs and just bring down the money where it would go directly onto her hands, And obviously at this point, I wouldn't expect it to return us the last 2 months, because we were expecting that just for moving costs. But how could I request that from her when obviously she never even got these 3 payments, the first 3 payments from her?
Okay,
So obviously we're not going to request that from her behalf, because if she didn't get this money, that's not fair to her either.
all right. I'm gonna listen to Mr. Sakareccia now, okay?
Of course.
What would you like to tell me, sir?
Thank you, Your Honor. Your Honor read my opposition.
I beg your pardon?
Did you read my opposition, Your Honor?
Yes, sir.
I-
Yes, sir.
I don't really need to go into it then in detail. Just that there's an agreement for judgment. My client feels that the tenant and alleges that the tenant violated the agreement. Tenant claims that she made payments to an account. I would never do that. She seems to be conceding at this point that I never received the payments, that my clients never received the payments. Even if what she says is true, the payments are late, insufficient, and a violation of the agreement for judgment. So we'd ask that the court deny her motion for a stay and allow the eviction to go forward.
All right. And you got to say everything you want to say. Sir. Mr. Sakareccia, you got to say everything you want to say. I'm not suggesting
yeah.
you should have more. It's only that particularly in this format, I don't want to be cutting people off.
Correct, Judge. Yeah, I mean, just the Western Union receipts that the order forms that I submitted, just would like just to point out that those don't even have a routing number on it to go to a bank account.
Right, I saw that. I saw that.
Yeah. They didn't have a routing number. It just stated this was directly to an account, and it was just an account that they state they wouldn't even give me the name holder to. And I asked them why, if I made direct payments myself, I said I had my ID and I made payments to this. Why can't they give me the account holder names? Yep.
Mr. Reese, we have to let Mr. Sakareccia talk now.
Oh, okay.
I want you to know I did hear all those, when you said all that, I did hear you. And also we have it on tape, so if I have questions, I can go back.
Okay. I'm sorry.
No, it's okay. All right, then as far as
So,
Mr.
Your Honor,
Sakareccia,
yes, I mean, after I received my client's daughter forwarded me copies of those order forms. So then I waited a couple of days to see how that would have played out. And then I sent an email to the tenant, which is, I think attached as Exhibit I, just trying to solidify the fact that we haven't got paid, even though it seems that she claimed that she was making payment. And I heard nothing from her, and she did not appear at the motions hearing. So here we are.
yeah, I see, I have that email, I'm looking at it now. All right, well, thank you both. Let me look through everything and make sure I can consider fairly everything everybody's given us, and we'll have an answer for you. Thank you very much.
Can I give my clients some sort of time frame on that, Your Honor? I'm sure they're going to ask me, and I've had very little experience with this type of administrative appeal, so I can have some guidance.
I'm gonna try to do it quickly, counsel, but
Okay.
It's a hectic time, just so you know. I don't want to promise, all right? But no, it's not gonna be 30 days or anything remotely like that. I'm gonna